the selection of judges. I guess there were 25 vacant seats in the Bratislava region, and another selection procedure was for the three vacant seats at the specialized criminal court in Pezinok. We found 3 judges for a specialized criminal court, and maybe the first remark is that there were 6 people successful for 25 vacant seats in Bratislava region. That's already one of challenges that we are experiencing in our system. So I will just briefly proceed with what was the recommended structure of the presentation. So about and then I will speak about my experience as a member of selection committees, maybe now for 10 years, I guess. So this is my 10th year of being a member of the selection committee. I will speak about how those members of committees are selected either. So as to criteria, if you want to become a judge in Slovak Republic, you have to have, based on constitution, you have to be citizen of the Slovak Republic, and you have to have permanent residence on the territory of Slovak Republic. You have to be at least 30 years old, and you should have university law degree, at least a master's degree. Then the constitutional condition is somehow it's hard to translate it in English language, but even in Slovak it's somehow strange. You have to fulfill the criteria of judicial capacity, which provide a guarantee that you as a judge will properly perform the office of a judge. And this criteria for judicial capacity means, as it is defined in the law, that you have moral standard and you have judicial integrity for due and responsible execution of the office, which includes that as a judge you don't have relationships with people from organized crime. So criteria for judicial capacity, we have this criteria from 2014, a moral standard and judicial integrity. Then you have to have full legal capacity, you have to be fit for the function health-wise, or you have to have this medical fitness. You have to pass exam already, so-called judicial exam or exam as attorney. The law specifies that you could even have prosecutorial or attorney's exam, and you're supposed to be irreproachable. Then you have to take a part in this selection procedure, in this process, and for I think 3 or 4 years, there is no selection for one empty vacant seat, but at a specific court. But as I mentioned, the law calls those selection procedures mass selection procedures based on regions. So there are not filled vacant seats at concrete court, but there is a number of seats specified by Ministry of Justice in 8 regions of the Slovak Republic. That selection procedure takes part in 1 day throughout the Slovak Republic, and bodies that are involved in the process are somehow the main body is Judicial Council of the Slovak Republic, because the president of the Judicial Council of the Slovak Republic sets time, and he or she appoints the members of selection procedures. There are so-called spring term and autumn terms of selection. In the last year, there were, because there are not the sufficient number of judges is not selected and appointed. That's why there were like two autumn terms last year. The general clause in constitution that speaks about the selection of judges or appointment of judges is judges are appointed and recalled by the President of the Slovak Republic at the proposal of the Judicial Council of the Slovak Republic. So the constitution does not really speak about selection committees. There was a discussion who can be part of selection committee, whether the government, parliament, and the government of the Slovak Republic can have the majority of seats in selection committees. The Constitutional Court of Slovak Republic said no. The executive bodies and the legislative bodies, they cannot have majority of their nominees in selection committees. So now the majority of people in selection committees are sort of like coming from the parts of people that are nominated by judges. But what I wanted to mention, and I've forgotten, but and I will speak about it again in a short time, that there is actually the database that is created based on the database of candidates that is created based on these results of the selection procedure. And people are, they have to undergo security checks. I will go through the process from Judicial Council, and then they are appointed by the President to the specific slot. The higher place you have in the database, the more points you got from the more points you scored in the selection process, the higher chance that you will be you will be appointed to the court that you want to be in. So the better place you have, you can choose the place, the court that you will go to. We also have this specific institute called sort of like flying judges. So there are judges who can move around the republic and fill the slots for judges that fill the slots, let's say, that are vacant only for a short time because, for example, the judge is staying at home because he or she is takes care of the children or a family member and so on. So the procedure goes like this. The procedure is initiated by the President of the Judicial Council. So he says, here we have this. You can appoint. You can apply for the selection procedure. It will happen at that time, and he nominates the members of that selection committee for each region. Two people are selected from the, let's say, basket or database created by Judicial Council. So members of Judicial Council create the database of candidates for members of selection committees. Usually in the database are members of Judicial Council themselves. And usually this database is created by judges. So they have majority, judges are usually, they have majority in this database. Then there is the second database created by Ministry of Justice. So Justice Minister creates database of other candidates for members of selection committees. Majority of those database is those people are usually from academia or they are attorneys. But I guess majority of people are from academia. In order to become the member of this database, you just have to be appointed from Justice Minister, and the law says that you should be able to check whether the judge fulfills all the needed conditions, and you yourself, besides this exam and the age, be able to become a judge yourself. So there are two people, and the fifth member is elected by the Council of Presidents, by the Committee of Presidents of Judicial Councils. or College of Presidents of Judicial Councils. Usually that member is from one judge of the court from that region. So yesterday, when I took a part at the selection procedure for Bratislava region, there were 3 judges, 1 attorney, and me as a scholar, people from academia. But you don't even have to be a lawyer in order to be in the database. So the strategy for Justice Minister was that she nominated some people from the field of psychologists. So those people can think about like the other characteristics of those candidates. Each applicant, when he or she applies, they need to send a CV cover letter where they explain their motivation. They have to declare the relationships with the people from judiciary. This is thanks to the need for transparency. So if your family member is working somewhere in judiciary, in Ministry of Justice, or he or she is in the selection committees, you have to declare this relationship. It has no consequences. It's just for transparency reasons.
Sorry, Lucia, can I ask you? Lucia, sorry, can I ask you what you mean by the family member? Is that something like a very broad definition, or a short, a strict definition?
There is a definition, if I remember correctly, coming from the civil code. So it's called like I don't know. I'm not sure whether I would translate it correctly in the English language. It's called like close persons. So there are family members. I think there are like 2 generations or something like that. And also the close person is the person that you live with in the same household for at least 1 year, and you whatever harm that person would feel, you will feel as your own harm. So that's a definition. Usually,
the cousins, or for example, cousin wouldn't be a family member in this way. The cousin.
I think it will be also the cousin, but I can check for you. Okay. So this is, I think, the second. It should be the second generation or second step. I will check in order to be like really precise. Usually, what you see in those declarations are because majority of applicants are coming from the field of law, sort of like court magistrates. I don't know whether it's a correct translation of the institute that we have, like people who are lawyers and they work in administrative, or they can decide some cases for themselves, the say tiny ones. So majority of those people apply to become judges as soon as they have this judicial exam and they reach 30 years. So you can see that their usually partners are working somewhere in the judiciary, maybe at the same court, but only a few applicants are coming from outside of judiciary, and only some of them are really like, let's say, a little bit more senior in their practice. So this is one of challenges that I will come back to. There was a couple of years ago, there was a research done by, if I'm right, Transparency International Slovakia, and they checked the selection procedures. I think it was in 2010, whether you having the selection procedure was changed in 2010 and 11. It became much more transparent. So we have really transparent procedure, but before that, they checked whether having a family ties in judiciary made you more successful, and they found out that really, indeed, it made you like the chance of you being successful is higher. And that they partially expected that it is because some kind of corruption, but it was hard to prove that. But through because of this transparency, the process it's quite simple to check those relationships. And the idea was behind that was that visibility somehow lowers the corruption. In fact, this need to enclose your relationships in judiciary was challenged before Constitutional Court. The challenger said that it violates the principle or the right not to be discriminated against, but the court said it doesn't have any effect on whether you can or you cannot become a judge. It doesn't have effect on you being successful. So it is not in any way discriminatory. Then the procedure usually takes place in 3 days for you as a single applicant. In the first day, day one, you have this written test. It has 40. There are 40 questions. You can get 40 points. Then, if you pass that one, there is a case study. It is valued for you can get 25 points. There is always the threshold. Many people are unsuccessful at the test already. Then in those case studies, but it's only really for a longer discussion. I can add to that maybe later on. Then you need to pass language exam. You can choose out of 3 languages. And basically, at the beginning, it was just translation of the Slovak text into English, English text, into Slovak language. Now it's your understanding of that English, German, or French text is examined, and whoever passes this is for the day one. And then on the second day, there are judicial decisions. So you get the case file, and you have 3 hours to write a judicial decision in this field of criminal law and the civil law. Then you can get 30 points from each decision. If you are successful on the third day, you have meeting with the psychologist. Those psychologists now are the ones that are employed by the state, and a majority of them work for prison facilities, but they are trained in this part. And so after that, they write. I think that they have like 4 or 5 hours for one applicant. They write a psychological profile, and then on another day there is an oral part, the oral sort of exam, and this oral part is recorded, fully recorded. What happened usually, again, this is the reason for transparency, and because what happened a couple years ago, and there was a research, or what was the translation, if there was only one vacant seat at the court, many people were successful or on a first position, and after the oral part of exam, they ended up second or third, and so on. So obviously there was a discussion how much points you should get in oral part and so on. And it seems that having these mass selection procedures or regional selection procedures and recording of the whole oral part somehow made it better. Then if you pass, you become you take the position in the database, and then you are checked. You have integrity checked by Judicial Council. Now it's only done by Judicial Council, and there are stages. If there are any irregularities in your property declaration, the integrity check goes deeper and deeper. Then you are either nominated or proposed for appointment for the president, and then president either appoints you or rejects the appointment. But the discussion is that the rejection for appointment, the reasons that there is really not really wide margin for discretion. Maybe something happens.
May I jump in?
Mm-hmm. Sorry, yes, sure. with a question? Or shall I continue?
Your microphone is off, Maxim. Your mic. Yeah. Okay.
Yes. Sorry, I have some problems with internet connection. I have a question on this like first part, test part. You know, in my country, in Ukraine, I hear many complaints that the tests are of very low quality, that the guys responsible for making them, they are like, it's just the best test. And do you have any of such problems in your country? Do everybody satisfied with the process of making tests, of like maybe just a couple of words about more words about this process?
Yes, there were complaints, and still are complaints, and there is a discussion that too many people do not pass the test. Those tests are prepared by Judicial Academy. The person who is responsible or mainly responsible for those tests is the guy, the scholar, quite well known in Slovakia. And because there was a suspicion again a couple of years ago when he was not the one who somehow took care of it. There was a suspicion that some people got to tests in advance. The test questions are actually published on the website of the Ministry of Justice, but only the first part of the question. So you have this like test question and then A, B, C, D. And usually it's, but I think that there are thousands something, or maybe even thousands of test questions. And there are usually like quotations from law. So what is from laws in the whole legal order. So the problem is that, or maybe this is one of the main problems why only those young court magistrates who have like 2 or 3 months in order to prepare for this test apply, because really it's a factual test coming from the law. So sometimes there is a discussion whether the answer was correct or not, and we usually, as members of committee, we just check the law, and it's usually written there. So it's hard to. So now there is discussion again, like whether it's okay to have all the spheres of law covered by it, and I can show you maybe or later on I will show you how what is public, what is available at the website of the Ministry of Justice. So idea was if it seems that maybe some applicants have access to tests, specific tests for specific courts in advance, how shall we prevail it? How shall we change it? And the idea was, okay, so let's publish all of it. And there is this electronic system that just randomly chooses the test questions. So you, as a selection committee, you have access to this electronic system, and you click on in the various stages of the selection procedure. You just click on the specific buttons, and there is this test comes up, and it's printed. It's not in front of the eyes of applicants, but right before that part. So there are, yes, indeed, there are complaints about the quality of tests, that they are like somehow too hard and too, you have to really have a great amount of knowledge as to facts about the law.
Lucia, just about the tests, do you have these tests? So you have like a double track, double stage of checking of qualification of the candidate. Like first is the judicial qualification exam, and second is case by case or vacancy by vacancy. You are also checking the qualification by way of legal questions.
Yes,
So,
yes,
is that
exactly.
the case?
So every
Okay.
candidate has to have this judicial exam or attorney's exam or exam of attorney or prosecutorial, and then this selection procedure for vacant seats. There's this, but not court by court, but regional amount of number of vacant seats. Then this selection is then the knowledge of the law is checked again. Yes, this was basically the reason, because there was a institute called Justični čekatelja. So there was an institute of somebody who was trained by a judge to be a judge, and he or she was selected in those specific procedure many years ago, and they were doing something else. They were doing less administrative job. They were sort of like prepared really for the function of a judge. But there was too much corruption, obviously, in selection of those people. That's why the system was changed. They didn't need to pass the let's say tender or whatever this hearing for the empty slot, for the vacant seat. But the system was changed that everybody who wants to become a judge, they need to undergo this selection procedure, where your knowledge is checked. So yes, of course, there is a discussion whether it shouldn't be only like one track. Yes, so there is like 2 times. So yes, that's the way how it is now. Okay. So really, you are sort of double checked. Mm-hmm.
Okay.
And so I don't know whether that's enough as to information. I would get I can reply the question. So as to transparency, really, you can see application, you can have the CV letters. What is important that you, from public, you can object to person who is in who applied for that position of judge. You can write objections against the person, and even anonymous, and the selection committee must deal with it. So you can say this person did this. I know he or she cheated when he was at university and so on. It doesn't happen often. To me, it happened only in the selection of presidents of courts. So we in selection committees got the letters, information like he or she as a judge or president of the court did this, and that's why he shouldn't be the president of the court anymore, and so on. So even the declaration. Then what is public are the minutes from that selection process, and the recording of the oral part. I will show you how it looks like from the selection from yesterday. So I will try to stop sharing, and I will share another screen. So it looks like this. Here you have the details of I will make it bigger. This is enough. So this is where I took part. Hopefully it works. Yes. So members of the committee are these people. It was done here. Here you have the list of candidates. You can click on the person, and you have all the documents, application, CV, cover letter, declaration, and it works. And after the selection, in the minutes, you can see the written reasoning of the members of committee for each participant. So here is the recording. It's usually like really many hours. It takes 1.5 hours per person. And here is we'll see how it goes, minutes, so you can see how it looks like. It's quite a large file, so probably I will get back to it later on, and I will show you so at the website there are the rules of selection of judges, and here is the database. Here is the database of test questions for judges. Show you how it looks like. Yeah, so it's really quite transparent. I don't know whether you can see now the questions or whether I still share the screen of internet.
Lucia, let me ask you, are these questions available in advance for the public so that I can see how many questions are there and what are these questions so I can just memorize by heart?
No. Only the yes, you can. I will show you what you see. So you, as a member of public, you see the questions like this. This is the document that you see. It has 21 pages, and here are the now it's like the topics. Oh, and before, yes, obviously, before it was the beginning of the, so it was changed recently, obviously. It was really the beginning of the question, and then the options were hidden. And now you can see that there are like, this is the question, protection of privacy under civil code licenses. Protection of person who died and so on. So you can see here are the, it's I think like almost really. So this is what you can check. It's yes, 1,000, 1,000 like the themes of the question. Judicial Council. What is the competent? What are the competencies of Judicial Council? How members are elected and so on. So this is public. And all the questions are coming from this. Nemis in idem and so on. So you can basically, yes, there are many people who go who take part in this selection processes, maybe for a couple of times, really, maybe even for I saw once the person who took part in 30 who tried for a position of judge 13 times, and this person really passed the test with a full points, but it was the guy, he failed at the judicial decisions. And here are the minutes. I'm not sure whether you can see it. Can you see now the minutes from the process? So
yes, we can see it. Yes.
Yes. So here you can see the numbers. All whatever happened. This is really, you see, it's 50 pages. So it's really describe what happened, who did what were the people, what was the what numbers they were given. So it's anonymous. You don't know whom you are evaluating. And in the end, this is in the oral exam. Sorry, I will try to make it the other way around. So this is the part from the oral exam, and you can give numbers for the knowledge, intellectual capabilities, creativity, how the person communicates, how the person knows himself or herself, how it's hard to translate it for me, how he or she is perceived as I don't know whether he or she has a behavior that is socially acceptable, whether this person is trustful, and emotional stability. And here is the written explanation.
This is an explanation, Lucia, about the points that you are giving.
Yes, exactly. So I can read you. I don't know. This is my. This is the person who was successful yesterday. So I wrote that she was very solid. Sometimes she just used these really legal formulas that do not have too much meaning, and you cover the. And you make sort of like shortcuts not to explain yourself. But yes, it happened also for other people, and she obviously read the the Code of Judicial Ethics in Slovak Republic. She was good in interaction about the ethical dilemmas. It's hard to read. Yes, the next time I have to write the the reasoning in such a way that I can myself read it, so it's not really readable.
Okay, Lucia, let me ask you: do you substantiate your points that you made for every aspect? So you say why you gave two or why you gave three?
No, that's just that's just oral. But what is some points are basically justified by this characteristic provided by psychologists. So, for example, they do IQ tests and they write you about this. So some of them they speak about. Psychologists somehow evaluate their creativity, even the way the people communicate, and IQ, and even partially emotional stability. So, and whether the person knows himself or herself. So you can use this psychological profiling for your own like filling those points. It's 1 to 0 to 3. And so I basically, and it's not even enough space, as you can see. You have the half of the page. So I just write or justify why I consider, why I believe that this person is suitable to be a judge in general. So, or I write, it's basically also the message for the Judicial Council. Sometimes some members of Judicial Council, before appointing or voting on the person, they read this. So here I wrote about this person that there is a tricky part in what he spoke about in the oral exam, because he himself believed that he is a proponent of natural law theory, and he believed that he can sometimes really just not use the law if he believes that the law is unjust, and he doesn't have to ask the Constitutional Court for. He doesn't have to challenge the law before the Constitutional Court if he wants to go against the wording of the law and even the intent of the law. So he himself saw the position of judge as somebody who delivers justice even against whatever the law says. So this for me was tricky. I wrote it here because I considered it to be tricky. So, but you see, it's really different. Some people write like maybe, yes, you see 1 sentence, 2 sentences. It depends. And my experience is that usually judges do not justify their themselves that much. So usually justifications or reasonings of members of committees who are judges are not that long. But it
Can
really,
this be challenged in court, this type of reasoning, or is there any practice on that? That maybe they feel that they have not been evaluated fairly?
Yeah, not in this oral part now. There were challenges before, as I remember, in the oral parts where the system of selection of judges was different for the when it was done for 1 empty vacant seat, because at the time it seemed that this oral evaluation or oral part really was very, very important. But now, since we have these regional selection procedures based on regions, less people get into this final stage than is the number of vacant seats. So almost everybody who gets into that oral part is successful. Of course, so couple years ago, there was a challenge at what court one person and the person who was successful in the selection procedure in the end. I think she was, or maybe I'm wrong, she was not recommended by the Judicial Council for appointment. because her brother was the participant who was successful. It was one empty seat. She was second or third after these written parts of, or more, let's say, objective parts of selection process, but she was the first one after the oral exam, and her brother was the president of the court. And at the time, the presidents of the court nominated the selection committee. And I think that's it was written in the somebody who was not successful wrote to the Judicial Council that that oral exam was corrupted, and because of that, now the oral exams are recorded. So sometimes, obviously, it happened that some applicants got easier questions, some applicants got harder questions. Now you can, when it's recorded, it's out. I think somehow this prevents this kind of corruption, but also what I said, what I can say, what is tricky part, what is the really tricky part for me is that yesterday, the person that was not successful in that oral part, we partially, what happened in that oral part, it was partially confirmation of what was presented in the mental or psychological profiling. And the tricky part is, what you can say about this psychological profiling in that oral part, because you don't want to, sometimes it happened that in psychological profiling, there were really the risky personal features. You want to take them into account, but it's hard to write in the document that is public. It shouldn't happen that you see this is in the psychological profiling and it's really risky. This person maybe even has paranoia and so on. So I think that's the reason maybe some people do not justify themselves so much. And yesterday she was told, and it was public, it was recorded, that she just, maybe she should take a deeper look into psychological profiling and think and work on some features that were mentioned there. I think it was like unlucky. I think that she should be, by the president of the committee, she should be advised to take a look not into psychological profiling, but into our reasoning why she was not selected. Because whoever listens to it, they might think that she has some mental problems, which was not the case. Obviously, they just advised her to be more persuasive and more. She should work on her self-confidence.
Lucia, sorry, are you done with the presentation so we can go ahead with the questions?
Yes. And this is the, sorry, that's the different paper. And I will just, you see, I took longer. And I will just, yes, basically, so here are the links, and here are the challenges that some of them I already took into account. What is criticized, very, very criticized, is the check of language skills. So many people in Slovakia, many judges especially, they believe that you shouldn't be checked, your knowledge of the foreign language shouldn't be checked, that it shouldn't have such a part of the, or so important. So maybe in the last procedure, out of 13 applicants, 6 of them didn't pass the language test. So that is the criticized part. Okay, basically, yes, I'm done, or I took too long.
Okay, thank you very much. I think I will just rush immediately to the questions because I know that you're in a hurry.
Yes,
let me ask you just some very brief questions from my side. First question is, do you have exemptions from judicial exam? Are people, some several categories of people who are exempted from the judicial exam?
Yes, there is. You can apply if you are a recognized scholar or recognized legal personality, and it needs to be confirmed by the Minister of Justice and Judicial Council.
I see. Okay, thank you. The second question from my side is, what is the level of trust of judiciary in Slovakia, and how many judges do you have?
We have now, I think, 1,300 something active judges in the system, because there is, I think that there are almost 150 who are inactive for various reasons, and the level of trust in judiciary is the lowest in European Union. It's less than 20% now, I guess, but I'm not sure I haven't checked the last barometer, but it's,
okay. And what is the reason of this trust? What is the basic reason of this trust?
Yes, it's a scientific question, and nobody performed the real check. But I can. So there was 2 years ago. The trust was low even before, but corruption in judiciary.
I see. Corruption.
Yes.
Okay, thank you. Does the selection committee sometimes appoint judges with bad reputations? And does that happen sometimes, that judges who have bad reputations have been reappointed or something like that?
Yes, there is no reappointment. So what I described was the selection procedure for new judges. This procedure looks differently when you are judge of lower court and you want to go to the higher court, and it looks differently. And yes, sometimes people with bad reputation are getting to the higher court, but it depends. Usually, people with I don't think that people with bad reputation currently are getting into the system of judiciary. I don't think so. There was one person that I remember that he was a tricky. He done controversial things as an attorney a couple of years ago, but he explained it so persuasively that in the end I gave him so many points, and even others they gave him so many points that he got into the system.
Okay, and one more question: the interviews are the interviews always public?
Yes. Whoever can be. Yes, you can enter the room.
Okay, what is the duration of the interview? What's the average duration of the interview?
It's usually 1 hour.
As a candidate.
In my experience, it's 1 hour, 1 hour and a half, but it depends. For some selection committees, it's like 20 minutes, 40 minutes, but for the ones I was in, it was at least 1 hour, at least.
And during these interviews, you as a commission members, you are asking all types of questions, value questions, philosophical questions, legal questions, do you do that?
Yes. Some committees, or it was the case before that, those usually judicial members of the committee ask about the knowledge of the law. And those persons are not. They do not ask about the knowledge of law, but it is now it's better, because already they were checked for the knowledge of the law. So there are more philosophical and questions about ethical dilemmas. We even play, because thanks to Jim, we simulate the ethical dilemmas with them. The same way as Jim taught us, because there are many people in selection committees, not many. Some of them that were trained by Jim. So we were trained by him, and we do this like activities with them. Sometimes they are surprised, sometimes not.
Okay, and my final question: are the scores so every one of you in the commission, that you write the scores, as I understand, the points, you write your points.
Yes,
are the points getting accumulated, and the best candidate with the best point gets the vacancy?
Yes, they are accumulated, and because there are so many vacant seats now, everybody who passes successfully becomes a judge in the end. So there is a database. They got into the database, and there are so many vacant seats that So as I said, there were like 25 vacant seats, and 6 people got through and in other regions, I think that there were like 10 or 15 vacant seats, and maybe even only one person got through the procedure. So now when you go, it doesn't really matter that much about the oral exams. What is tricky for me, and that's really the last one that the trust issue in committees. Somehow the last time it happened to me that I gave to, the question is how much you should share about the points you are going to give to the candidates to other members of committee. So it happened to me last time in the previous selection committee, and even before, that I spoke about the numbers, the score that I will give. And in the end, this candidate didn't pass the threshold by 1 or 2 points. and another member of committee said, okay, so I will give him better score.
Really?
So
And
yes.
specifically and artificially got higher score from this commission member, and that's why he got passed.
Yes.
I see. And one last question. I'm sorry. My last question is, do you have some kind of judicial mafia like in Georgia who is helping their fellow judges to get reappointed or promoted?
I think that there was, I wouldn't say that there is one judicial mafia but there are, I think the groups of people who help each other somehow to get to the upper or to get into the system to better positions. I don't think that it's like a mafia, but there are like groups of judges who help each other. That's what I believe in, and it's not only one group but smaller groups.
Okay, thank you. I'm done. So,
okay.
So any questions, please, dear colleagues?
May I have a question, but I don't want to really stop Lucia from going if she's in a hurry. So.
Yes, it's like, no, please ask, and then I will, yes.
No, my question, because you didn't really have time to go into the challenges, and it seems like one of the challenges that you listed is a shortage of judges. So it seems like if you go up to a certain point, there's a very good likelihood that you're gonna get appointed. But the problem that you highlighted is that more experienced lawyers are not really keen on applying. And my question is, what's the reason for that? Is it because they it's not paid enough compared to like a private practice in law, or is it because they don't trust the system, or it's overcomplicated for more experienced people? What's the reason in your view?
I don't think that the money is the reason because in every country, when you are good in private practice, you make much more money than being a judge. I think it's the case in almost in every country that like being a top lawyer, you make more money than every judge. But the how much you make, it's quite much. So I don't think the money is the main reason. Probably the main reason is really that you have to pass the test and you have to study for the test like being 20-year-old student. You cannot pass this test without studying for 2 or 3 months. So I think that in my opinion, probably this.
Would you consider the change? Is it worth changing the system in order to attract more experienced, like advocates?
Yes. Probably yes. That's yes. I think it's worth doing it. And another reason why I think they don't apply, that we don't have specialization now. So when you apply for position of judge, you don't know where you will end up. So you can end up as a criminal judge, a criminal law judge, as a judge in family matters, in other parts of civil law, commercial law. So as soon as this new judicial map is passed, if it is, I believe, and you will have specialization, I believe this would be one strong incentive, like you would apply, because then the system we expect, or the idea from ministries is that the system would be changed and you would apply for the position where at least like criminal law, commercial law, civil law. And then I think it will, the other people would be attracted, the more senior members of profession.
Thank you.
Thank you.
Thank you, Lucia. Eka, you had some question, Eka? Oh, okay. Eka is gone.
Yes.
Oh.
Good evening. No, here. Good evening. Sorry, my video will be off. Can you hear me?
Yes.
Yes. Thank you for your detailed presentation. I will just clarify one issue. It seems very similar to Georgia, that the evaluation part and this point system you demonstrated in your presentation. And I wanted to ask if the procedure in general is regarded as well substantiated and trusted and effective in terms of appeal, because you mentioned that evaluators not really explain the reasons behind their evaluation. And is it assessed as a good substantiated procedure, or are there maybe, I don't know, from Venice Commission or other counterparts, the recommendations to make improvements in this regard?
Mm-hmm. I think this the system is changing. Thank you for the question. The system is somehow evolving. The new transparency system was, or this kind of system was firstly introduced in 2010, I guess 11. And I think it's really, in comparison to other or the previous system, it's really very well I think that when you check the minutes and all the minutes from the selection procedure and all the points, you really get an idea why and check the oral part. You listen to the interview. I think that you will be certain whether it was okay or not okay that this person became a judge. So I think it's really, for me, it's really and even from the point of outsider now, it's trusted, because many people who didn't become judges or had no chance to become judges a couple of years ago, now they are becoming a judge. The judges. The problem was obviously a couple of years ago that there was only this one vacant seat, and the oral part of exam that was subjective was not recorded. So then what? The things happened, and we I was in database for I was the member of database candidates for selection committees, but for a couple of years I was not nominated. So only some people were nominated as members of committees. We were not never nominated, and now it is now we are nominated again by the new president of the Judicial Council. So I think it is trusted, the system, how it looks in the last couple of years. But what I mentioned, yes, that sometimes the trust within the committee is important. But I really trust this system.
So you say that professional judges are appointed through this procedure, and people with integrity are appointed. Then how come there is this critique about lack of trust? And
I think it's yes. I think it's a lack of trust of existing judiciary. Like the judiciary per se doesn't have a trust, but not the selection of judges now. So I think the new judges are quite trustful. The least trusted are. Or based on what happened, we had this so-called Trima corruption case. Majority of people who were involved, or judges who were involved in this corruption, were judicial officials or judges at the higher courts. So this was, I guess, the problem. The new judges at the district courts, I think that they are trusted quite much, but the judicial system, it really takes a lot of time. And now I think when you would measure the trust in the new selection procedure and the trust in judiciary, it would be completely different, because it's like two separate things. Yes, and like what judges, what I said, what they write in oral, why I voted for this judge. Okay, they are maybe they just write a couple of sentences, but in my experience, I'm sure that they have a good reason. It's just really the space to write your opinion. It's short.
Thank you so much. Thank you.
Okay, thank you, Lucia. I think we are done.
Thank you. Can I have only
Maya.
One little question. Yeah. Hi to everyone. Lucia, I know that you are in a hurry. So first of all, thank you for participating here, and also for this beautiful explanation and presentation. I'd like to ask some kind of general question concerning the division of duties and responsibilities between the Council of Judiciary and the Selection Commission. What can you say? How can you evaluate? Are there any kind of system of check and balances between these two bodies, or the council itself, the commission itself rates on behalf of the Judicial Council. Is the selection commission's evaluation mandatory for submitting the candidates, or the Judicial Council can somehow overcome it and ignore it? Can you briefly speak about this? I mean the division of powers between these two bodies. Thank you, Lucia.
Thank you, Maya, for the question. So the main like power balance, or who is in selection committees in the end depends on the president of the Judicial Council, who selects from those databases. But in any other way, this selection committees or commission is completely independent in such a way that they sort of fulfill their role that I mentioned. And then the main responsibility, obviously, based on constitution, has Judicial Council. It happened for a couple of times that people who passed who were successful based on the evaluation, the stage of Judicial Committee, were never appointed. A couple of years ago, just Judicial Council didn't explain its decision, and they just said, is the person who I know it's called Revitsky case, that's the name of the guy. Judicial Council just voted no, but there was no explanation. It was challenged, the decision of Judicial Council was challenged before the Constitutional Court, and Constitutional Court said it needs to be clear for the person. You don't have to provide reasoning, but it needs to be clear for the person that you decide upon why this was the case. So based on the discussion you have or whatever, the person has to have an idea why you didn't appoint or why you didn't nominate this person for appointment. And then the Judicial Council, again with no discussion, just nominated this person, Revitsky. What is happening before the Judicial Council is public. I remember that they didn't nominate the person that we selected in September last year, and because they have another information on that people, so they have their own integrity checks and so on. And for example, in the integrity checks, they found out that this person repeatedly violates the traffic rules. And when he was asked about the traffic rules, he sort of blamed everybody else, let's say simply, and he became sort of arrogant, and they just voted no. And so they have more information than we have, and they have their own like interview or hearing. So it's sort of independent.
Mm-hmm. Thank you.
Is this enough, Maya? Okay.
Yes, absolutely.
Thank you
Lucia, thank you very much. Lucia, I think we had a very interesting presentation about Slovakia, and many questions that we had, practical questions, were also provided answers. However, we will keep in touch on this point, and if the other members of the network, they have questions about Slovakian system, probably they can send it. So that
sure.
we are available, and we can clarify those points later.
Yes, thank you very much. We are in touch. It was really great to see you.
Thank you.
Thanks, Lucia. Great to see you as always. Bye. Wonderful.
Great. Bye, guys. Have a great evening. Bye.
Bye. Okay, dear colleagues. So we shall now proceed with the next presentation, which is the case of Georgia, and I will do the slides, and Eka will also do some more clarifications. I will do the major part of this presentation because Eka, she had to go out for a while, and now she's back. However, I will do the slides, and then Eka will add more details if more details are required. First of all, I will start with an interesting slide. which is showing whether the lawyers are trusting the appointment, the system of judicial appointments. Just a second, sorry. Oh, here it is. Okay. Approximately 2 or 3 months ago, we did well, actually, it was the start of the start of this year. We did an interview of the lawyers asking multiple questions about judiciary, the trust of the judiciary, the fair hearing, the disciplinary matters, the existence of the problems inside judiciary. And one of the questions that we asked the lawyers was, do you believe that you can become a judge with relevant qualification? If you have a relevant qualification, do you believe that you can become a judge without improper influence or any type of improper interference? Here is what was the question. We have interviewed approximately 80 lawyers, and that was the answer. 45% of the respondents, they said it's possible in some cases. So in some cases, you can become a judge without undue interference. 30% of lawyers, they said that it's impossible. It is impossible to become a judge without interference, without undue interference. 8% of lawyers, they said, I don't know. And 11% of lawyers, they said, it's entirely possible. So we can say that minority of lawyers in Georgia, they believe that you can become a judge without improper interference, just by your qualification and by your skills, which shows that there is a very small trust towards the judicial appointments here there's a small level of trust towards the judicial appointments here in Georgia. Now, to proceed with this issue of the appointments, I will start with the slides. Sorry, I will just close this one. And start with follow the same scheme that we have done with Lucia. It's about who can become a judge, and very briefly, it's a 1, 2, 3, 4, 5 criteria. The citizenship criteria, competence, but it means legally competent. You're legally competent. And age criteria. It should also say the age criteria, which is the age of 30 years. Age criteria. Over the age of 30 years. Sorry. Educational criteria, which means that you must have a master's degree, and you must go to the High School of Justice, and also judicial qualification exam. However, the judicial qualification exams, they are not required for the Supreme Court judges and so they are not, and also the High School of Justice. It's not required for the Supreme Court judges. And the language, you should know the Georgian language and the absence of criminal record. Just what is interesting is that if you want to become a regular judge, you have to have judicial qualification exam and the High School of Justice, and mandatory training in the High School of Justice, graduation. But if you want to become a Supreme Court judge, you don't have to have qualification exam or go to High School of Justice. Time of appointment, we are appointing judges for lifetime, but initially for the period for the probation period of 3 years. And the exceptions are former judges who have 3 years of experience. They will not be appointed for probation. They will be appointed for lifetime, the former judges. General rule is the lifetime appointments. The appointing body is the High Council of Justice, except for Supreme Court. In case of Supreme Court, we have two agencies. One is the High Council of Justice, who is proposing, and the Parliament, which is electing the candidate. The criteria, you can see the criteria on the slide. It's the two basic criterion are mentioned by the Constitution of Georgia. This is the competence, the integrity criterion, and the competence criterion. The integrity criteria, the components of the integrity criteria are personal good faith, professional conscience, independence, impartiality, personal professional behavior, personal professional reputation. And the components of the competence criteria, they are the knowledge of legal norms, the ability to legal reasoning, writing skills and verbal skills, professional qualities, academic achievements, and professional training and professional activity. There are quite detailed description of how each of these criteria is demonstrated and what are the elements of each of these criteria. I'm not going to go in each of them, but just for example, I will just do a couple of examples. For example, you can see that on the screen. When evaluating the personal good faith and professional conscience, consideration shall be given to honesty, good faith, consciousness, responsibility, transparency, accuracy, precision, financial obligations, precision in meeting financial obligations or paying a bank debt, utility or other fees, paying a fine for violation of traffic regulations, etc. When evaluating independence and partiality, consideration shall be given to independent decision-making skills and resistance to the pressure, to firmness, inviolability. When evaluating by personal and professional behavior, consideration shall be given to interaction with the colleagues, or ability to manage emotions, dispute in court, or to which this person has been a party. Then when evaluating candidate by personal professional reputation, consideration shall be given to the business and moral reputation, authority among legal professionals, community, the character of interacting with legal professionals. Evaluating by knowledge of legal norms, then you can, it's not that difficult. I'm not going to explain that. Legal reasoning, you can see that on the slide. Writing and verbal communication, professional qualities like punctuality, diligence, ability to think independently, stressful environment, managerial skills. Academic achievements separately, will be assessed separately. Professional activity shall be assessed separately also, professional activity of the judge. That's it. So how are these criteria assessed? The integrity criterion is assessed by compliance. So you comply or you don't comply. However, you can partially comply. You can also partially comply. Right. Then competence criterion. Competence is assessed by following points. To the knowledge of legal norms, 25 points. The ability of reasoning the ability of reasoning, 25 points. Writing and verbal communication, 20 points. Professional qualities, 15 points. Academic achievements and professional training, 10 points. And professional activity, 5 points. Obtaining information about candidate. Information about candidate is obtained by the special department in High Council of Justice. The former is so there's a different procedure for slightly different procedure for former judges. So their 5 decisions will be picked up randomly for evaluation. Okay, then all candidates have to submit the property declaration. That's clear. Then when scoring the candidate, so process by itself is based on the competition. When there's a vacancy, the candidates apply for the vacancy. There's an initial screening of the applications, the shortlisting, so that if they meet the minimal qualification criteria, there's an interview. Then there is a search of information about this candidate by this department. Then there is an interview, and then there is a voting. There's a voting. Only a candidate will be assigned to vacancies when we are talking about the integrity criterion. More than half of the full composition of High Council of Justice members must consider that the candidate complies or fully complies with the good faith criteria. So more than half of the members of High Council of Justice should say that you are you have integrity. And then when evaluating the competence criteria, the sum of points obtained by the candidate should be at least 75% of maximum number of points on the competence criteria. After the voting, what happens after the voting is that Secretary of High Council of Justice publishes the justification. It should include the description of the procedure and description of the judge appointed, including the points that accumulated and the conclusion of the good faith of the candidate. Now, when we are talking about the assessment of which candidate and the members of High Council of Justice, they are producing special forms. They have to fill in special forms. Just where they pointed the scores and also some reasoning. However, this is more stricter. The reasoning part is more stricter when it comes to the Supreme Court justifications. In case of Supreme Court justification, Supreme Court appointments, it's even more stricter procedure. And I will just talk about this a little bit later. When we are talking about appeal, what are the grounds of appeal? So if you are not appointed and you want to appeal, on what grounds can you appeal? If there was a bias from the member of High Council of Justice, if there was a discrimination, if there was an excess of power, and there was an abuse of powers, if there was a false information provided to the council, and if the competition was conducted in violation of the procedure established by legislation of Georgia. So basically, you cannot appeal based on substantial reasoning, based on the reasoning part. You cannot say that the reasoning was bad, that I was better than the other candidate, and that's why it's not fair or something. So you can only argue the procedural violations, the procedural discrimination, bias, or any other, or false information, which was grounding the decision. Okay, and now talking about the Supreme Court. What is the Supreme Court? At one glance, it's a cassation instance. It has 28 judges appointed for life. It should have 28 judges appointed for life. Right now, we have 19 judges appointed in the Supreme Court. The appointing bodies are High Council of Justice and Parliament. So they are nominated by High Council of Justice. They are elected by Parliament. Qualification criteria is the same as the first instance judge, but you don't have to pass judicial qualification exams or you don't have to graduate High School of Justice. Next. We had a different procedure for the Supreme Court before 2017 constitutional reforms. There was a president was proposing and Parliament was approving. Parliament was electing the candidate. But after 2017, this power to nominate the candidates was delivered to the High Council of Justice. So it was removed from the president. It was delivered to the High Council of Justice. Stages of the appointment of Supreme Court judges, procedure inside High Council of Justice is a short list. Basically, it's more or less the same as the trial judges. It's a short listing of applications, hearing a candidate in High Council of Justice, scoring and justification of scores, shortlisting according to the scores obtained, and voting. So basically, the principle is the same you need to score each of the criteria and you need to justify your score. However, there was a study of the scoring of these justifications by Georgian NGO, Social Justice Center. They produced a study and they said that this reasoning of the candidates is of very poor character. It's not very much reasoned. The decisions, the scores are not sufficiently reasoned, and they are not always consistent. For example, if you have got two candidates with the same type of qualifications and the reasoning is almost the same, you say that this candidate was good. This candidate was good in answering the questions about civil law or criminal law, and then finally you make a difference. You are scoring the candidates differently, while the justification is the same for both of the candidates, but the scores are different. So that's one of the problems of this justification. One of the problems of justifications. Also, the justifications or reasoning is routinely. In most cases, they are routine type of reasoning. It's not a profound type of reasoning of the candidates. Finally, who is going to be elected? The candidate who obtains most highest scores going to be shortlisted, and finally there will be a voting process, and then they have to be voted once again to be proposed to the Parliament of Georgia. Then procedure in the Parliament of Georgia is quite simple. There is a hearing before Legal Committee of Parliament. Then the hearing, the politicians are asking questions. Also, NGOs are asking questions. Public Defender is asking questions, and also Bar Association is asking questions. However, the hearings in the Supreme Court, in practice, they continue for 6 or 7 hours. It's quite a long procedure. And politicians sometimes or often they are also asking political questions, and judges they are attacked by the politicians. They try to somehow defend themselves from these politicians. It's very funny to watch how the judges are trying to defend themselves from the angry politicians in this during these hearings. Finally, there is a parliament voting process, and the parliament, and in order to become a judge, a Supreme Court judge, you have to obtain 76 votes out of 150 MPs. So it's majority, a simple majority is enough. Now, what is the critique? Now, what about the critique of the current appointment process? Sorry, what's that? Oh, that's a different slide. I have to talk about the critiques orally. I don't have a slide, but talking about the critique of the judicial appointment in Georgia. First, the biggest critique of the judicial appointment in Georgia is that we have this influential group of judges who are supporting the fellow judges, and there is a deal between judges and this clan, that we call them the clan, that if you appoint me, I will be your faithful servant for my lifetime. So that's a very allegedly it's a very beneficial deal for everyone. So if you vote for me, I will become a judge and I will be loyal for the lifetime. However, this is something which is not brought from which is not unfounded. This claim is not unfounded. Why? Recently, we had a judicial conference about a month ago, and 4 candidates were elected in High Council of Justice. 4 candidates were elected in High Council of Justice. There were 4 vacancies in High Council of Justice, and there were 285 judges participating in judicial conference. All 280 or 281 or 279, I mean, absolute majority have voted for these 4 candidates. 4 vacancies for 4 candidates for 4 vacancies. Everyone voting for them. So it looked like a Communist Party gathering. You know, there was no competition between candidates. There was no speeches prior to the election process. There was no alternative opinion. 4 candidates for 4 vacancies, and everyone voted for them. So this means that there's, you know, there's no dissenting groups. There are no dissenting groups in the judiciary who can compete with each other, and it means that there's quite a big problem of this judiciary being unanimous on defending the interests of this influential group of judges. Of course, there are more people in the judiciary because there were approximately 340 judges. So some of the judges, they did not go to this conference. It's okay, it's understandable. But the problem is that this deal, which I talked about, is a big challenge. The deal between the High Council of Justice and judges. So if you vote for, I will appoint you if you vote for me later on for the judicial conference. Trading of power. So let's say a second. Actually, I do have a slide about that I can show you. Sorry, I will just show one simple slide here. Okay, I think that's it. What happened in 2019? I will show you, and I will going to be quite brief now because I think I'm expiring my time. What happened in 2019 competition when there was, and I will show you the slide. Which proves that the members of High Council of Justice were acting in agreement, in a preliminary agreement to appoint a certain number of people in High Council of Justice. Here is what happened in 2019, 2 years ago. There were, I will start, there were 20 vacancies in the Supreme Court. Then what the 20 vacancies in the Supreme Court. Then there were approximately 140 applications. And there was a short listing of these vacancies because 50 people had to be shortlisted. And how did the shortlisting happen? The shortlisting happened in a preliminary agreement with of the members of High Council of Justice. They agreed, the 10 people, they agreed among each other that we are going to vote for specific candidates, and we want those specific candidates to be shortlisted. And I have made a picture which shows how they made this agreement. I made a picture which shows how they made the agreement. This is a picture in colors. It shows the members of the High Council of Justice. Here are the members of the High Council of Justice, 1, 2, 3, 4, 5, 10 members of the High Council of Justice, which is the row. And you can see that row. They agreed that they will shortlist following people. White candidates, to classify the candidates into white, black, and yellow. So let's suppose I am the member number 1 of the High Council of Justice. Member number 1. I am voting from this list of 140 people. I am voting for the 20 candidates, which is here. You see the column, the first column, and it's the 1, 2, 3, 4, 5, 7, 2. These 20 people, and you can see these 20 people, they are white. Well, let's say I have conditionally classified them into white, black, and yellow. So I am the first, I am the member of High Council of Justice #1, and I voted for 20 candidates which are white. You are, let's suppose, Nino, you are the High Council of Justice member #2, and you have accidentally voted exactly for the same 20 candidates which are here. 1, 2, 3, 4, 5, 3, 7, 20, exactly the same 20 out of 145 people. Okay, then let's say Jim, you are the High Council of Justice #3, member #3, and you also accidentally, you also voted absolutely the same 20 people. And then who is this? Eka, you are High Council of Justice member #3, and you also accidentally voted for the same 20 people here out of 140. What happened? That what happened that the candidate, let's say the first candidate who was here, he got 4 votes from me, from Maya, from Jim, and from Eka. Nino, Maya, Jim, and Eka, we are voting from absolutely the same people, same 20 candidates out of this 140. Now, what happens next? Next is the High Council of Justice member #5, 6, 7. They are also in agreement with each other. So the High Council of Justice member #5, 6, and 7, they also voted for absolutely the same people, 20 candidates who are absolutely the same. So how many is that? Initially it was 20, addition was also 20, this is 40. We now have these 40 people here. Additionally, we have High Council of Justice member #8 and High Council of Justice member #9. They also voted for absolutely the same people. They voted for 15 black candidates and 5 yellow candidates. 15 black candidates and 5 yellow candidates. High Council of Justice member 9, he also did the same. And there was a High Council of Justice member #10 who has done something different. Namely, he voted for 15 white candidates and 5 yellow candidates. So this is a table which was probably drawn in advance by these people in High Council of Justice because they wanted 45 people to be shortlisted. And so they shortlisted these 45 people by this chart. So now it's like, we are like 4 members, you vote for the same people. 3 other members, you vote for the same people. 2 other members, you vote for the same people. And the 10th member, he votes for 5 yellow candidates so that they can get additional 3 votes. I mean, maybe it's a complex chart, but this is something to show you that 10 people in High Council of Justice, they distributed the role among each other, and they wanted to shortlist for 45 candidates. They shortlisted the 45 candidates. This is what happened in 2019. Now, finally, and on the final notes, these interviews which happen in the High Council of Justice and in the Supreme Court, these interviews are very interesting because you see a lot of questions, legal questions, political questions, or philosophical questions, but sometimes there is a suspicion that these questions are agreed in advance with the candidates. Also, you have a problem of nepotism because you have people who are relatives to each other, but they still run for these competitions. And this was quite well disclosed by one member of High Council of Justice, Nazi Janezashvili. He was always shouting for such cases of nepotism inside the judicial appointments. There is also a problem that the legal professions, they don't trust the system of appointment. And there we don't have a wide competition now for judicial vacancies. there is also another problem of High School of Justice, which is also locking the system, because if you have to go to High School of Justice, which has limited vacancies for every year, and it's very hard to get into High School of Justice. So High School of Justice also became one lock for the system. And lastly, I'm going to show you another slide, and I will finish, and we'll just let Eka to complete. Here's my slide. Okay, this is slide, sorry. That's the slide. Okay, what happened from 2012 after the new government and before? We have studied judicial biographies for 300 judges in March. About 4 months ago. And then out of the 300 judges, 81 have been appointed after 2012. 219 judges have been appointed before 2012. Among these 81 judges appointed after 2012, only 11 people have come from outside judiciary and 70 have come from inside judiciary. These are 84 former assistants, 30 of them have been trial secretaries, 16 have been held positions in High Council of Justice or some other positions in the court. What does it say? What does it say? It says that after 2012, by the situation of March, only 81 new people have become judges. And out of these 81 new people, 70 of them have already been serving in judiciary as legal assistants or secretaries or some other positions. So only 11 people have come completely from outside judiciary. So this is the final, so after 2012, only 11 people have come from outside judiciary by the situation of March, because this is a March data. And we picked up 300 judges. There was a little bit more, but we had data from 300 judges. So basically, just to finalize, out of these 300 judges, 110 have already previously worked as judicial assistants, 70 worked as trial secretaries, 84 as any non-judge position in court, 63 have previously worked as a lawyer, and 55 have previously worked as a prosecutor. Well, that shows particularly the data after 2012 that shows that judiciary has locked up itself. Judiciary has locked up itself. They are not accepting people from the outside. They are accepting people from the inside. It's also another big problem. So thank you very much. And I think I will let Eka, if she wants to add some more points, and then we'll finish.
Thank you.
Before Eka
Yes.
starts, let me interrupt. Maybe it's worth mentioning that we have also new achievements in the recent appointment.
Maya, your voice is interrupted, Maya.
The son of the lay member of Judicial Council was appointed as a judge. Can you hear me now?
Yes.
Now yes. It was interrupted previously, but now we can hear you.
Now?
Yes.
Yeah. Okay. It was mentioned that in the recent process of appointment, we have new achievement already. Moreover, of this that you already have mentioned in your presentation, that we have a judge who was appointed in last week. He is the son of the acting member of the High Council of Justice. Lay member who was all this time voting for the candidates of the judge members, and he did not have any initiative or any decision against the judge members' will. So now he was awarded, and his son was appointed. Even in those periods when his father was the member of the High Council of Justice. Of course, he said that there was some conflict of interest, and he didn't vote.
Participate, yes, he did not participate in the voting process. Yes,
yes, did not participate in the voting process, but during the voting process, he was the acting lay member of the High Council of Justice.
Okay, yes, okay, thank you, Maya. Eka, please.
Yes, he just very brief comment. He did not participate in the process, but his brothers did the job. So okay. I mean the other members of the council. So, well, thank you, Kaja, for your detailed presentation. I don't have very much to add in terms of procedure, but I would summarize the major problem which the Georgian judiciary faces is this closed system of appointments, which always ensures that only judicial, only people who worked or are related somehow to the judiciary, to acting judges, etc., are appointed on the judicial positions. And this is what we try to address with the reforms to open the system. And it should be considered that I think this is very unique for Georgia, that High Council of Justice is the one which can somehow evaluate professionalism as well as integrity and each and every aspect of the candidates. I think it happens nowhere else that only one council with its 15 members is so competent that they can evaluate and assess whether the candidates are suitable for the judicial position in each and every aspect. This leads us to this need to introduce reform which would respond to this problem, exactly this problem, that professionals will be engaged in the selection process. Professionals and not only judges who are not necessarily suitable to evaluate each and every criteria, or non-judges who might be of different backgrounds and different professions, which who would not be able to evaluate all the aspects of the candidates. And as soon as we have this, new procedure which engages more different professionals in this process, we need somehow to reform evaluation system itself. It's true that we say that we have a very detailed evaluation system, but I would not say that these criteria are backed up with concrete methodology how to evaluate in this criteria, how to evaluate the candidates, whether they comply with this criteria. So I think the major problem with regard to criteria is still that the methodology is lacking. In addition to what I already said, we need to have reform which would ensure that only professionals and people with integrity are selected. Otherwise, even if you open the competition and more people participate in the competition, you still have a problem if the evaluation is not perfect. So This is just to summarize the major problems with
Eka,
Georgian
so let me ask you this question. If we did not have so-called mafia type of governance or judiciary, which means that some people get together behind closed doors and they talk about who must be elected and how to reach that result, how to achieve that type of outcome. So they agree among each other who is voting for whom, how they justify the scores. They agree among each other, and then they get the results because they are the majority. The majority takes decisions, and that decision has been preliminary agreed in a preliminary secret gathering by the secret gathering of this clan. So let's suppose that we did not have this type of situation, and we had 15 independent members of High Council of Justice, and if they were assessing the candidates independently from each other. Let's say, I believe that this is better because he speaks better, because he writes better, because he talks better, he has got great values, but you have different idea. But finally, it's a reasoning of 15 different individuals, which comes to a best outcome, because I may be wrong, you may be right, Maya may be wrong, but finally, it's not possible that all 15 of us, we are wrong. So that's the reasoning part. It's the same as a jury trial. The jury trial, the logic of the jury trial is that 12 people are never wrong. They are usually they're right because they think independently. Because they are not a clan, they are not a mafia, and they have brains, and the 12 people in the jury, they think independently, and they are never wrong. They are always right. That's the reasoning behind. But if you have a mafia sitting there who's not thinking independently, it's not a group of individuals who think independently, but it's some kind of mafia gathering, then it's not working. Of course, it's not working. That's my point. Thank you.
Yeah, yes, I see, but you know what? You need, in terms of the system in place, you need a system to avoid, to block the possibility to create this clan. I think this is very important. System is ensuring that clans are not easily created. If you don't have a system in place, then there is a good room, very good space to create, to establish a clan inside the system.
Just to, because, I'm sorry, that's not it. That's another chart, sorry. I think we're finishing the Georgian part, but just to clarify the last point, and then maybe Ion also has some questions. I will just once again show you this chart. This chart says, and I failed to clarify it for you very well. This is a chart which was made by the members of High Council of Justice in 2019, 2 years ago. This chart is about this 45 shortlisted candidates that they did. You see, there are 20 white candidates. You see, there are 20 white candidates, 20 white. I'm sorry, I will clarify it once again. There are 20 white candidates in this chart. There are 20 black candidates in this chart, and there are 5 yellow candidates in this chart. So I have divided this group, 20 whites, 20 blacks, and 5 yellow people. And you see how they divided the votes among themselves, so that everyone, white people, they got 5 votes, black people, they got 5 or 3 votes, and the yellow people, they got 3 votes. So everyone, they are shortlisted. Black, white, yellow, everyone is shortlisted. And that's how I made it. And I'm pretty sure that somebody who designed this chart, they probably classified these people into colors, because I came to the same conclusion that they were classified into colors. These candidates, they were classified into some kind of 3 categories, and that's how they did it. Thank you. Okay, Ion, maybe you have some question about the Georgian system. because we are now Georgians talking about talking among ourselves.
It's just a different mechanism that I see. So I have to understand more in depth what is happening. But I will speak. I mean, when you give me the floor, I will explain what here in Moldova.
Okay, thank you. Nino, would you like to add something? Or?
No, I think if we continue, we can continue endlessly about this, and I think we'll Georgians have many other opportunities to discuss this. I'm on the same page very much on a lot of the things that you talked about. So I think it would be great to hear John's experience with the Moldovan system.
Okay, thank you very much, Ion. Now we are coming to the last presentation. It's about Moldova, and we're very interested to hear what are the major points, what are the similarities or differences, and how is the system working. Thank you. We're listening.
I need your help to.
It's about share screen. It's a share screen function which is below on the bottom of the share screen. Okay, you're coming. Okay, great, great.
So just to start with some recent survey that was conducted by the Legal Resources Center in 2020. And the question, to which extent judges, just a second, sorry, will see the advancement of the reforming the judiciary since it was started and the positive impact that would have. You can see that almost 20% of judges and 10% of judges strongly agree with it, and 47 and almost 44% somewhat agree. But most interesting is the data below. I mean, just to compare the two surveys that were conducted in 2015 and 2020, you can see that actually less judges for the last period of time believe that that they agree with the statement that the reform of the judiciary started in 2011 had a positive impact for the judiciary. And you can see the data for judges, for prosecutors, and for lawyers. And anyway, all these three important legal professionals in 2020 are less that would support this statement. The interesting question that worries me is the question, the results that were provided on the question that do you personally feel independent in discharging the duties of so judges, prosecutors, and lawyers. Having a percent of 20% to 25% of judges that we say that rather yes or rather no, I think that this is an issue of concern for all of us, because having judges that are afraid of prosecutors or lawyers to adopt any kind of actions or a decision, this is an issue of concern. And probably this is the results that all of us have to think, to which extent the Supreme Council of Magistracy or any of the other self-administration bodies support, promote, or adopt their own motivated decisions. But for more details, I will speak further. So, criteria to be a judge. I guess that in any of our region, there is a body that's generic name of the Judicial Council. In Moldova, it's called the Supreme Council of Magistracy, is the main body of the judiciary, which with the responsibility for judicial appointments, evaluation of judicial performance, promotions, inspection, and disciplinary matters also covered. Within the Supreme Council of Magistracy, there are several of the affiliated bodies, disciplinary board, judicial inspectorate, selection and career board, performance evaluation board, and ethics commission. since 2011, all these bodies were just subordinated to the Supreme Council of Magistracy, but later on, in 2018, these bodies were gained with more independence, and that's why they are affiliated with the ICM. There are two ways of a person to be appointed as a judge. If he or she graduates the National Institute of Justice or among legal professionals. The Supreme Council of Magistracy regulation provides several of the criteria, but the main one is the efficiency of judges' work, yes, the quality and professional integrity. And each of the criterion has its own detailed points. My issue is that with the professional integrity, and I'm recalling your debates on this assessment, sincere to be, if a person has integrity, so this is it. So it has it, you know. When it does not, so that person does not. It should not be not to hold that position of being a judge. As I mentioned before, there are two ways of a person to be appointed as a judge. A person has to graduate the National Institute of Justice and has to have at least 5 years of experience before being appointed as a judge, or among those that are coming from the legal professionals, and the list is approved by the government or can be revised by the government. Also they have to have at least 5 years of experience. About the criteria, so judges.
Sorry, Ion, can I ask you quickly? So you say that if you have 5 years of experience as a lawyer, you worked as a lawyer and prosecutor for 5 years, you don't have to study in the National Institute of Justice.
Don't have to study, but you have to pass some of the exams, and the composition of the committee is approved jointly by the National Institute of Justice, the Supreme Council of Magistracy, and the Supreme Council of Prosecutors. So in any case, a person that's before being appointed as a judge has to follow some exams before the National Institute of Justice. And again, the composition of the committee that would evaluate are composed of the representatives of the National Institute of Justice, Supreme Council of Magistracy, and Supreme Council of Prosecutors. The only thing that I will say is that we have to think and to assess in depth to which extent do we need to have those graduates of the National Institute of Justice to follow up to 2 years of courses at the National Institute of Justice, because those persons are receiving monthly allowance, and they calculated from the salary of a judge, and to which extent in parallel we have to think to which extent we have to admit so many persons as prosecutors or lawyers, and just to follow and to pass several exams of the National Institute of Justice, and having this imbalance, and to decide what will be the best or more efficient for Moldovan system to pass. Because for the last years we have seen by law, I forgot to mention that by law, the graduates of the National Institute of Justice are obliged to participate in the contests that are organized by the Supreme Council of Magistracy, and if they don't participate, they have to pay back all of the allowances that they receive for the 2 years as the graduates of the National Institute of Justice. But it's somehow not fair, you know, because you might participate in all these contests, but for the last years that we have seen that graduates of the National Institute of Justice, they are not among those that are appointed as a judge. So most favorable persons are among those with that have the background of prosecutor or lawyer. Is it clear now? Can I move to the next slide? Okay. So the appointment of judges in general are done by two institutions. Judges at the district court level and appellate courts are appointed by the President of Moldova, and the Supreme Court judges are appointed by the Parliament. Why I somehow deleted the Parliament, because now for the third time there is a law amendment to amend the Constitution, as all the appointments in the judiciary to be done by the President of the country, and to exclude the Parliament for the Supreme Court of Justice. We have also some legal requirements to be appointed. Before being appointed as a judge, you have to have impeccable reputation, to be a holder of the citizenship of the Republic of Moldova, have domicile in this country, to have legal capacity, bachelor degree or equivalent. To graduate from the National Institute of Justice, and I already explained previously about this system. This length of the experience that I mentioned, you have to be a judge or assistant of judge of the Constitutional Court, judge in international courts, prosecutor, law professor in high accredited education institutions, lawyer, judicial assistant, or clerk. My issue is that with the law professor in high accredited educational institutions, because it seems that any law professor is by default might be a candidate to be appointed as a judge. So what are the challenges in practice from my perspective is that for the first time, adoption of amendments to the Moldovan Constitution is not adopted by the Parliament of Moldova. Actually, these law amendments refers as the main issue, they refers to exclude the 5-year term of a judge and to strengthen the role of the SCM. So we see that these 5 years of initial term to be appointed as a judge is threats judges' independence and has to be excluded. And I guess in your countries there is also a similar, let's say, step before being appointed for the lifetime.
Yeah, we also have 3-year probation period.
Yes, in Moldova it's not called probation, but it's initial 5 term. And I think that's from the legal perspective and the procedures that have to be followed probably is the same. The next one is that ensure the proper organization of the contests. In Moldova, we have a practice when judges are participating in the contest, but it's almost not clear why a person didn't gain the sufficient number of the judges among Superior Council Magistracy members to be appointed as a judge. It seems that everything stops at the discretion of the SCM members to be in favor of a candidate or not. And the most problematic issue is because the SCM does not motivate its decisions. So there is no problem for me, for example, if a person is not voted, but the Superior Council Magistracy has to motivate why they didn't. Based on the Moldovan law, for the final grade, the Superior Council Magistracy has a discretion of 20% of the total amount of points And we have seen that for the last contest, actually these 20% that was used and provided for the Superior Council Magistracy actually helped some of the candidates to be appointed, or for the others, that was the Superior Council Magistracy gave the minimum number of the votes, of the points. That's why those candidates finally were not appointed.
Jon, can I ask you for a clarification for a minute, if I may? Because you mentioned initially that there are affiliated bodies and one of them is a selection and career board. And could you clarify the respective roles of the board and the council? And you mentioned 20%. Is it like a, because they, if I correctly understand, first the evaluation is done at the level of the board, and then the council itself does some sort of evaluation and can change basically the whole ranking by way of adding certain number of points, and basically whoever was it. Could you please explain that in a few words, if it's
yes, definitely. So the selection and career board deals with the candidates for the position of judges or those that would like to be promoted. So a person comes with the grades from the National Institute of Justice. They are evaluated by a certain number of criteria by the selection and career board, then goes to the Superior Council of Magistracy. So the selection and career board actually has a weight of 80% and the SCM 20%. And they are calculated. The most problematic issue for myself is that while the criteria for the selection and career board are approved in some rules by the Superior Council of Magistracy, there is no clear for any candidate how these 20% are calculated by the Superior Council of Magistracy members. When we speak about the judges that would like to be promoted, or those that would like to be appointed as court presidents or the vice court presidents, they have to be selected. The activity has to be evaluated by two boards, the selection and career board, and then by the performance evaluation board, and then by the Superior Council of Magistracy. That's why I mentioned that finally these 20% that were given by the Superior Council of Magistracy actually that's finally made the differences between the candidates. And it seems that as SCM having no clear points and procedures how to evaluate a candidate, is abusing of their discretion as to appoint or not a judge or to promote. Nino, was I clear?
Yes, that was clear. Thank you. So basically, they don't substantiate those 20%, and that's why it's problematic.
Exactly. So fast they do not motivate those 20%, and finally they do not motivate the final decision of when they appoint or decide to appoint or to promote a judge, or when they decide that none of the candidates gained a sufficient number of the votes, and then that contest is failed and the new contest has to roll on. So my point of view is that if you have good candidates, you have to appoint. If you have some reserves with regard to the integrity, you have to raise these issues at the level of the Superior Council of Magistracy. And if a candidate has issue with the integrity, that person could not be appointed or promoted. Therefore, it has to be not appointed or to fire. If there are some of the issues regarding the activity, experience, and so far and so on, that person that participates in that contest has to be appointed. We cannot trust to all of the procedures that were done or evaluation that have been done by the National Institute of Justice or by the other boards of the SCM. And by the way, all these criteria are approved by the Supreme Council of Magistracy, and these are not written or imposed by the parliament in a law. So the SCM, when it sees some of the lack of the procedures or some issues with the criteria, it's upon the discretion to amend these rules. We had a very strange and very bad, actually, practice when, due to the fact that the Supreme Council of Magistracy lacked to motivate its decisions, we have several of the appellate court decisions when they obliged the Superior Council of Magistracy to appoint judges in district courts, appellate court, or the Supreme Court of Justice. So can you imagine that a court or an appellate court would impose a Supreme Council of Magistracy, and body which is established by the Constitution, has its own specific mandates to appoint or not a judge, actually has to follow or to let's say to follow what an appellate court says. Hopefully, as far as I know, these court decisions were or has to be contested before the Constitutional Court, because this is also a matter of the constitutionality. Yet we have two cases when actually the Supreme Council of Magistracy ruled and decided as to put in action the appellate court decisions, and they appointed those judges. I think that this is an abuse of power, and there is a crime how they did. Since 2018, we have a good and modified system of appointment of judges. All the contests are organized at least 2 times per year, based on all of the vacancies per system. So, for example, in June 2021, the Supreme Council of Magistracy decides and publish actually all the vacancies that's on whole the system, both for the as judges and also for the administrative positions. And the candidates have the possibility for 3 months at least to ask for the evaluation, to be registered in a special registry of the candidates, and then to participate in the contest organized for the Supreme Council of Magistracy. While these changes from 2018 were aimed to be very clear, both for the candidates and also for the SCM, to have these periodic contests, unfortunately, the Supreme Council of Magistracy came back to old rules to organize some contests when the vacancy in a specific court appears and not their whole system. The other one, as I mentioned, if a person has no issue with the integrity, why we should evaluate it? If does not, that person should be fired or not to be appointed as a judge. If you have a different views, let's debate later on. The other challenges that we have judges that are criminally investigated for illegal enrichment, bribes, sorry for my mistakes, and the other corruption-related cases, and they are in office, they rule, they issue the decision. What will be the trust of those persons that are in office, but in parallel, they are criminally investigated for the corruption-related cases? Another challenge that I think, and I mentioned before, that we have a few cases when this, based on the votes of the parliament, actually 3 candidates for the Supreme Court of Justice were not appointed. I think this is an issue, and that's why Greco recommended Moldova to exclude the parliament from this process, These rules, they are also in those amendments to the Moldovan Constitution that I mentioned before. Hopefully, at least for the first time, we might exclude and all this issue of the appointment of the Supreme Court of Justice judges by the parliament.
Dion, can I ask you one quick question? Were these candidates interviewed in parliament? Were these oral hearing or something, public hearing or something?
Very interesting question. That's actually the opposition. So let's say the opposition, which are pro-European parties, requested the majority of the parliament to organize these public hearings, the interviews in the parliament, but the majority rejected this initiative.
Very interesting.
Yes, but in past, that was a practice that the candidates for the Supreme Court of Justice will be interviewed by the parliament. And actually, of having this parliament to interview a candidate for the Supreme Court of Justice, having no clear rules, this is for sure a matter of the political discretion to appoint somebody or not at the Supreme Court of Justice. Now, I think that this is a challenge that recently the mechanism for the external evaluation of judges and prosecutors from Albania has been validated by the European Court of Human Rights. Why do I mention it? Because the current, the President of the Republic of Moldova and the pro-European parties are in favor to initiate and to put in place the external evaluation of judges and prosecutors. And I think it will be implemented. And actually, this was the reason why the President of the Republic of Moldova refused to approve the latest justice sector reform strategy, because it was not mentioned about the external evaluation of judges and prosecutors. And I think that on this issue, we will come back soon, because in few days, actually 9 days, we have the snap elections, parliamentary elections. And if the now opposition party, the pro-European parties, will win, so we can come back to this issue very soon. Very soon, it means in the next 3 weeks, but no more than 6 months. Another challenge that we will have, that we have a different court outputs, the decisions for judges involved in the Russian laundromat case. We have a Russian laundromat case is about laundering of the more than $20 billion from the Russian Federation using the judicial system of the Republic of Moldova. And they are 16 judges that were criminally investigated of being involved in this case. And now judges at the district court started to issue the decisions, and some of the judges were acquitted and some of the judges were charged for being involved in this corruption scheme. The last 2 points is that Greco recommendation from the 4th evaluation round of the Republic of Moldova is about the reservation of the ex officio participation of the Ministry of Justice and the Minister of Justice and the Prosecutor General as members of the Superior Council of Magistracy. This is an issue that was included in those amendments to the Constitution, and the lack of the selection or poor selection process of the members of the Superior Council of Magistracy, among judges and actually among law professors, which does not ensure that sufficient information which is available to the voters and the public candidates. Last year, the Venice Commission actually made an opinion on some law amendments regarding the SCM members, specifically on the increasement of the numbers of the law professors, how these law professors were appointed in last year. And in less than a month, the Constitutional Court of the Republic of Moldova decided that the law amendments that aimed to increase the number of the SCM members, more specifically including of the law professors, was declared unconstitutional. And the last point, that's the challenges in the practice, is the lack of investigation mechanism to assess the integrity and the asset declaration of judges, prosecutors, but of any of the other civil servant. Here you can see a few pictures of some judges that included in their asset declaration and donations from their relatives. Of that you can see 30,000 euros, dollars, and even more. And I think that this is an issue where the integrity and tax authorities have to look here. We have several situations when poor relatives with very low incomes appear in the asset declaration of judges and prosecutors of having these donations. So I see that this is a failure of our institutions to have a look more in depth in such cases. So the eventual short-term solution that I see is definitely the adoption of the amendments to the Moldovan constitution regarding the exclusion of the initial term of 5 years for judges, and also some of the other law amendments that are aimed to strengthen the competences and place of the Supreme Council of Magistracy. Second is to organize and organize actually the contests and not to admit the suspension of the contests or even to make some of the contests as being failed. There is a high priority to implement several of the Greco recommendations regarding the judiciary and also the prosecutions because they are similar. They are referring to almost the same issues, to judges and prosecutors' career and the role of the Supreme Council of Magistracy and the Supreme Council of Prosecutors, and also regarding the integrity and anti-corruption in these fields. The next one is the motivation of the Supreme Council of Magistracy decision, especially of those 20% of the total points or grade. Starting the extraordinary and external evaluation of judges and prosecutors. The election of the Supreme Council of Magistracy members among judges, which have to be elected in October 2021 at the Judges Assembly, and to law professors. It has to be done as soon as possible in a contest organized by the Parliament. And a genuine check of the asset declaration, property, and incomes by the National Integrity Authority, the Tax Authority, and the other institutions. And finally, that I think, which is applicable for Moldova, I don't know for Georgia or for the other countries, adoption of the Treaty on Change of Data for Verification of Asset Declaration, which is an initiative of the Regional Anti-Corruption Initiative, right? Shortly. By date, few countries adopted this treaty, except Moldova and Romania and Bulgaria. So if you will have this, many of the Moldovan civil servants, or in general citizens, are holders of the Romanian citizenship, and that will give the possibility for the Moldovan authorities to find the same person, but with the Romanian citizenship, and to check their assets in Romania and the other countries, members of the Regional Anti-Corruption Initiative. Thank you.
Thank you very much for this extensive overview of your system and your challenges. I do have some questions, and I'm sure some other participants will also have the questions about the about the Moldovan system, which is also quite interesting, quite complex in a way that it it has some kind of desegregation of function in the appointment process between several actors somehow. While in Georgia, for the regular judicial appointments, it's not desegregated. It's only in the hands of one specific body, which is High Council of Justice. But in case of Supreme Court appointments, it's actually in the hands of two bodies: it's the High Council of Justice and the Parliament, and they are working closely with each other. And then it's some kind of a deal, which happens in Georgian reality. But my question to you is that for your Superior Council of Magistracy, are the judges electing their colleagues on the basis of competing? Are the judges competing with each other? Do you have judicial associations competing for vacancies in Superior Council of Magistracy? The second question is if the law professors that you talked about, is there also a true competition in Parliament when they are elected in Parliament? And also another question is, do you have judges reappointed because their previous period was expired and they were reappointed massively in the last several years, which was a case of Georgia. In Georgia, all judges have expired their mandate. They were massively reappointed for lifetime. Yeah, thank you.
Thank you. So, among some problematic issues that were declared as unconstitutional that I mentioned before was to make more clear all this procedure and to have this procedure of election of the SCM members among judges more clear, more visible, also to allow judges to participate in so-called electoral process. But I do believe that the parliament, this composition of the parliament will approve very soon all these law amendments just to make sure that the candidates for the SCM positions among judges are benefiting of a transparent process for the selection appointment as SCM members. However, I would say that the current status quo, so the legal provisions and even the rules that are approved by the General Assembly of Judges, does not exclude or will narrow or make less transparent all this process. All these law amendments were developed just to make sure that we are not that any leadership of the court or the SCM would not impede a candidate for the position of the SCM, because in the last period of time we used to have these impediments for judges. About law professors, in 2020, in December 2019, law amendments to ensure a more transparent manner of appointment of Supreme Council of Magistracy members among law professors were adopted. However, the process how was organized by the pro-Russian alliance was done in such a way that all those law professors were 4 law professors were appointed, was more than clear that they are politically influenced process. that time, several of the NGOs claimed that some amendments to be made by the parliament to make sure that all this political influence to be as less as possible. Finally, 4 law professors were appointed. But the Venice Commission, in 2 their opinions, one interim and one final opinion last year, evaluated and said actually that all those law professors were appointed in a politically influenced way. And we looked to the several of the issues to make sure that all these appointments are done on merit based. I do believe that any law that would any country adopt will be not sufficient when the parliament avoids some of the processes, or we had a situation when, based on the unclear and too much discretion of the members of the parliament or members of the commission to grade the answers of the candidates. And actually we have seen that the best candidates from our perspective were defavored in comparison with some of the candidates. So I do believe that any criteria we might put there, it might be blocked, stopped by the political parties.
Did you mention also the external evaluation of judges? What do you mean by external evaluation of judges?
Yes, just a second. You asked me about the reappointment of judges.
Okay, yeah.
For what I recall is that with few exceptions, but exceptions were in back in 2010, all of the judges were reappointed after this 5 initial term. Probably I missed 2, but no more than 3 other judges. So let's say no more than 3 judges were not reappointed in office after this initial term. But I do believe that following several of the problematic decisions that were taken by some young judges, especially a judge that annulled the elections of the mayor of the capital of Moldova, of Chisinau, I do believe that in the future we might have more judges that will be not reappointed by the president of the country. About the external evaluation of judges, this will be the system that was done in Albania. Some of the good practices and ideas will be also imported from Ukraine, because they are most recent examples. And but I cannot give you more details about this external evaluation of judges, because there is no law or even draft law initiative in this respect to mention more in depth or some examples, because there are different views how to be done. But all these experts should be external judges and should analyze at least the quality, including the quality of the judgments, and for sure if a judge appeared or issued a decision that was the object before the European Court of Human Rights, of illegal decisions, of illegal arrests, illegal wiretapping, so interceptions, and the other criteria that will be adopted very soon after the if the pro-European parties, at least no more than 2 actually, but it will be clear that this legislation will be adopted with a high priority.
Okay, thank you.
Thank you, Ion, very much. I have one little question. concerning gender balance, I mentioned on your slide that there were only 2 women among so many men. Can you tell a couple of words about gender balance? Does someone take in account, or it's never mind for the appointing board body?
I don't think that the Supreme Council of Magistracy ever motivated or fought about the gender balance in the system. The only I can say is that currently we have the judicial system in Moldova looks like young professionals. So we have the majority of judges in office, which means 450 judges. So half of them are young. It means that less than 10 years of experience. And the majority of judges in office are women. I'm not sure and have no data at the moment regarding the presidents and vice presidents of the courts, because mostly all of these positions are vacant. But an example that I can provide is that both positions of the vice president of the Supreme Court of Justice at the moment are led by 2 women. In the Supreme Council of Magistracy, there is a balance of women.
Okay, thank you very much.
You.
Thank you, Ion. Any other questions if you have participants?
The only thing that I would like to mention regarding the gender issue is that female judges are discriminated when it comes to their career of being appointed or even promoted, because many of female judges used to be on maternity leave. And although in all of the countries, this is also included in the professional experience, many times that was an issue of in-camera debates or even in public debates that a female judge would defavored because she was on maternity leave. We have also a case that was when the Equality Council and Non-Discrimination Council issued a decision against the Superior Council of Magistracy because a female judge was not transferred in a same level court because somebody claimed that that judge was sometime on maternity leave. So I would say that women's faces with discrimination and issues when it comes of their career. And this is not a surprise for me. I don't know if it is for you, but the most that actually act in this regard to discriminate, to make a female judge to feel discriminated are women themselves.
Okay, thank you. I think we are coming to the end of our today's roundtable. I guess there are plenty of similarities between the countries that we have heard of, from Georgia, Slovakia, and Moldova. We are facing with the heritage from the past heritage from post-Soviet type of judicial systems. We are facing of a challenge of culture, absence of, in many cases, we are facing a challenge of culture, absence of culture of judicial independence, culture of informal influences, political interferences, a culture of political interferences. But I believe that each countries also have unique challenges, which are very specific for your countries. By this time, the question that you raised about Ukraine, and we are very much interested about Ukraine experience and this Public Integrity Council, and also the vetting of judicial candidates. Right now in Georgia, there's a big political debate ongoing about judiciary. We had a severe political crisis in Georgia recently. The opposition has boycotted the parliament for several months, and there was an EU mediation process. There was the EU led by Charles Michel, who came to Georgia, who has led the process of mediation between the opposition and they signed, between the opposition and the government, and they signed an agreement. One big part of the agreement is the judiciary, which says that there should be a fundamental reform of Georgia judiciary here, and there should be a reform of the High Council of Justice, the process of judicial appointments. And now we are facing a situation in which the government does not want to pause, to suspend the process of the appointment of the Supreme Court judges. And the opposition is boycotting the process. And the civil society, part of the civil society, is also boycotting the process. So that's a very...
Sorry to interrupt you. What is interesting is that in the Republic of Moldova, at the moment, actually the institution that is boycotting the appointment of judges is the Supreme Council of Magistracy itself. But this is also due to some of the issues regarding the political instability in the Republic of Moldova. I think that in our countries, there is no news that the political, let's say, situations or environment does not negatively influence the issues regarding the appointment or in general judges' career.
But Yon, let me ask you this question, just a very brief question here. Do the political parties try to interfere in the process of appointment and have their own candidates becoming judges? Is that something that happens in Moldova, that political parties try to interfere in the process and have their people in judiciary?
I have no proofs in this respect when it comes to judges, but there are very big rumors that the court presidents or the vice president of district court, of the appellate court, or even the Supreme Court of Justice are, let's say, favored or not favored by some of the political parties. The most evident issue in this respect, it's at the parliament, because the parliament appoints the Supreme Court judges or judges as the chief justices or vice presidents of the Supreme Court of Justice. So there, by the parliament, when it's done by the parliament, is very clear. But when it comes to be appointed by the president here, I mean, is not visible. The only thing that I can conclude in this respect is only when some, following the investigation documents done by journalists, we can claim that a person, a judge, was favored before being appointed or in his or her career by a certain of politician, but in general, this is excluded at the when it's done purely by the Supreme Council of Magistracy and the president of the country. When is involved the parliament, so then it's a different way.
Okay.
An indirect influence, just to complete your question, is that if we take into consideration the appointment of SCM members by the parliament among law professors, yes, here we can say that the political parties have an interest in this respect. If some members of the parliament or politicians are starting to write different claims against the judge, to initiate some of the disciplinary procedures, or some requests to the National Integrity Authority to assess judges or prosecutor or any servants' asset of declaration. Yes, here from this perspective, we can say that political parties are influencing judges' career.
Mm-hmm. And do political parties trust judiciary themselves? For example, if there is an election dispute, do political parties have a confidence that this election dispute with the government will be solved fairly by the judiciary, or the judges will be always in favor of the government, in favor of the current dominant political party? Is that the perception? What is the perception, that the judges are in favor of the government, or judges are neutral on political cases?
I have no answer in this respect, because we had so many elections for the last 6 years, presidential elections and parliament elections and snap elections. We had at least 3 governments for the last years, yes. So I can't say, but the assumption or the perception that judges are likely to follow the decision that will be favored the current leadership, the government or the parliamentary majority, yes, it is. But this is, I guess,
there's a perception anyway, right? Oh, yeah. Okay. Thank you. Thank you. Okay. Well, dear colleagues, I think now we can finish today's roundtable. I would like to thank everyone for your precious time. That means that every one of you is dedicated to these issues, and you are not sparing your time to discuss and talk about these issues and make share your experiences. We will continue proposing some other topics in the future. And because the network has approximately 30 members, I'm confident that there will always be some enthusiasts who will be willing to share their experiences from their countries. So I'm confident that this network will continue successful functioning. We will make this video, today's video, available for everyone, and also available online, so that the public and the outsiders, they can follow what is happening in Georgia, what's happening in Slovakia and Moldova. So I guess by now we are finishing. Thank you, everybody.
Let me in a couple of words. I want to somehow today consider the topic of our next meeting. I suggest to speak about court presidents. We have spoken about it with Nino, and now I would like to ask her if for the next hour meeting she will be able to speak with us about the court president's power in Czechia, because it's some different model we know, and also, if you agree with me, let's schedule this meeting for our next meeting, and we also we can discuss what are their duties, what are the existence of this institute, the pros and cons of the existence of this institute, and I think this will